Good afternoon, everybody, and welcome to this webinar on consumer law aspects of the Digital Markets, Competition and Consumers Bill. The parts are relevant in parts 3 and 4 of the bill and the connected schedules. The Chief Executive of the CMA, Sarah Cardell, has recently described this new bill as having the potential to be a watershed moment in the way that we protect consumers in the UK. In exploring how that is so, and indeed whether that is so, I'm delighted to be joined by an expert panel of my colleagues here at Monkton Chambers, George Pretz, KC, Rob Williams, KC, Jonathan Lewis, and Khatija Habjeski. We plan to run this session as a discussion between us, which I shall try and guide and divide broadly into 3 parts. Firstly, we'll discuss the current position in overview. Secondly, we'll discuss the procedural changes to the enforcement regime introduced by the bill. And thirdly, we'll address changes to substantive law. We'll try to make the discussion as accessible and clear as possible whilst you eat your lunch, but it may be helpful to have a copy of the bill to hand or on screen whilst you listen in, but that's not compulsory. Finally, also just to remind you that there's a Q&A box. Please do put any questions in there. We have a full agenda, but if time permits us, we'll try and keep our eye on those questions and address them either at the end of the session altogether, or the speakers will try and weave in answers as we go along. But without further ado, it would be useful to start with a sketch, I think, of the current consumer protection regime, because it's obviously quite a complicated picture. Rob, could you talk us through the substantive law framework as it currently exists?
Yes. Hello, everybody. Sorry if I sound a bit snivelly today. I'm a bit under the weather. It's not coronation fever, I don't think. I think it's something else. But yeah, so picking up your question, Jack, there's really quite a big contrast between the consumer law framework and the competition regime, where until Brexit, we had essentially one UK regime from the inception of the legislation, which covered both the substantive law and matters of procedure. In consumer law, the substantive law and the enforcement regime have evolved separately. And there's been a lot of iterative reform, including over the last 20 years. So there are a lot of moving parts. And on both sides, EU law was historically driving the shape of things. On the substantive side, those of us of a certain age may remember studying contract law and the Unfair Contract Terms Act 1977 being supplemented by the Unfair Terms Regulations in 1994. We had those 2 regimes until 2015, when the 2 sets of controls on unfair contract terms were consolidated into the Consumer Rights Act 2015. That is one big part of the CMA's toolkit in these cases, and the reforms we're talking about today don't touch on unfair contract terms in that sense. The other main plank of the CMA's enforcement work in this space involves the regulation of unfair commercial practices as opposed to contract terms. And this deals with conduct which misleads consumers either actively or by omission, or which impairs consumer choice in the case of so-called aggressive practices. And the current law is contained in the Consumer Protection from Unfair Commercial Practices Regulation 2008. It's often called the CPRs. These again implement EU law 2005 directive, and the CPRs basically swept aside a bunch of UK laws dealing with things like trade descriptions and so on. Part of the test under the CPRs is concerned with whether conduct affects the consumer's transactional decision. But a transactional decision is not a transactional decision in the sense that we think about it, which is to say a decision to enter into a transaction. It can be any part of the consumer's journey, ultimately. And so we see the CMA's modern casework focusing on things like the operations of websites and the applications of, for example, countdown timers at particular stages of the online process before you get to the point of committing to the transaction. And of course, there's other consumer protection legislation in this space that Khatija's going to touch on a bit of it later on. And there are a whole host of domestic laws which deal with specific issues. But in my experience, anyway, it's those 2 planks really that form the main focus of the CMA's work in this space.
And so that's an overview of the substantive law position as it currently exists. What about the framework that's currently in place for the enforcement and procedural position?
Well, it's interesting because in the competition area, we often debate the question of whether there should be a prosecutorial model, but in fact that is what we basically have and have had in the consumer area, going back at least to the Fair Trading Act 1973. What we have now is largely in Part 8 of the Enterprise Act, and it's a complicated regime with different enforcers and some criminal aspects and some civil aspects. But if we focus on the role of the CMA and its predecessors, we have a regime in which the CMA carries out investigations into infringements of consumer law using statutory powers. And if the party under investigation doesn't fall into line as part of that process, then the CMA applies to the court for an order enforcing the law. And the current regime is more or less based on an EU regime dating back to the late 90s and a set of regulations which had the dramatic title, the Stop Now Orders Regulations 2001. I don't think there was an exclamation mark in the title, but there probably ought to have been. The Stop Now regulations applied to enforcement of EU consumer protection legislation. And in the Enterprise Act 2002, EU and domestic enforcement were brought under one roof. There is still a hangover in Part 8 now from the old law, because there's still a distinction between so-called domestic infringements and what used to be community infringements. They've now been rechristened Schedule 13 infringements, which I think is a bit of a failure of imagination. But that's
in the Brexit legislation, isn't it? The Schedule 13 amendment.
And in Part 8 now. It's been carried into Part 8. And the core tool under that regime was the power to seek an order from the court bringing the infringement to an end. So it's effectively an injunction of a sort. Clearly, that's an important power, but it's a bit of a one-trick pony. And over time, that power was supplemented by additional enforcement powers, again rooted in EU law, which allowed the CMA to seek what were called enhanced consumer measures. And to highlight two of those forms of relief, the CMA can seek a compliance ECM, which is a measure designed to ensure that the conduct's not repeated. So that goes beyond just stopping the infringement, but actually introducing checks and balances into the party's business model. And going further, the CMA has the power to seek what's called a redress ECM, so effectively compensation schemes. And we've seen measures of that ilk agreed, for example, in the CMA's current leasehold case.
And I know you've acted for the CMA in a couple of these cases in the past, Viagogo leasehold, for example. I know we've acted together. What's been your practical experience of the operation of that current regime in practice?
Yeah, well, obviously, I speak for myself rather than the CMA when I talk about this. I mean, I think back in the days of the Stop Now order, which were before my time, you can see from the case law that the proceedings were effectively an application for an injunction of a sort. And the form of relief was fairly straightforward: stop the conduct, don't repeat it. And of course, as soon as you start drafting, you have belt and braces orders and all the rest of it. But it was effectively a fairly straightforward form of relief. Once you move into the world of ECMs and compliance ECMs, the position obviously gets more complicated, and you end up with an order which is much more prescriptive about the steps that need to be taken by the party from time to time. It looks much more like a regulatory intervention in some senses. But of course, as things stand, the effective regulator in that sense is the court, because it's the court that's asked to make the order, and the CMA has to persuade the court to engage in this detailed review of the scheme to make sure that it's reasonable and proportionate to control the conduct in question. And those orders can be quite long and involved. The one that we dealt with in Viagogo, as you know, was in excess of 30 pages. And so that's always struck me as a challenging aspect of the current regime, trying to persuade the court to get on board with something of that order of detail.
And George, have you had any different experiences?
I was going to make a slightly historical footnote, but one that might interest some people, which is that the power of what is now the CMA to go to court to deal with people who are engaging in successive consumer law infringements actually dates back a bit further back than that, right back to 1973 in the Fair Trading Act. And there was a regime when I was at the OFT as a very baby lawyer in the 1990s that was still going strong, and I remember working on it, and that was then to some extent then taken over. Well, in the end, it was taken over by the then community law to which Rob refers, Stop Now orders, and then that was all consolidated into the Enterprise Act. But the idea that what is now the CMA could go to court and get and do something in relation to companies that have a sort of long string of bad behaviour towards consumers it dates back a bit further than the involvement of EU law.
Okay, so that's where we've come from. I'd like now to turn to where we're going with the new provisions in the bill. I think it makes sense to start with Part 3 of the bill, which deals with the enforcement of the consumer protection law. So it provides for new procedures for the court-based enforcement, new enforcement roles for the CMA, and new remedies and penalties. I'd like us to start our discussion with the court-based enforcement before moving on to the significant new CMA powers. So, John, I wondered whether you could give us an overview of whether there's been any significant change to the procedure for court-based enforcement.
Well, good afternoon, everyone. In short, Jack, the answer is no. I don't think that the procedure itself overall has changed dramatically. As the explanatory notes to the bill put it, the new procedure really simplifies and enhances what we have in the Enterprise Act. I just want to take everyone quite quickly through some of the key parts of Part 3, just to give you a sense as to how it works, comparing it to what we've just heard Rob discuss. Starting with Clause 139, which provides us with a very helpful roadmap for all of these provisions. Then Clause 140 provides that a commercial practice is a relevant infringement if it meets 3 conditions. The first is that it harms the collective interests of consumers. And of course, that's a phrase all of us are very familiar with and is deeply rooted in the Enterprise Act itself in Section 211. The second condition is that it meets the UK connection condition. And this is something that's set out in Clause 141 of the bill. And we'll perhaps return to it a bit later. But essentially, it does what it says on the lid. A trader has to have a place of business in the UK or has to carry on business here, or its activities have to be directed against consumers who are here. The third condition is that the activity has to meet the specified prohibition condition, which is set out in Clause 142. I think we can all see the modern drafting that's used here, using the names, conditions, and having set out in different clauses of the bill. But that specified prohibition is simply that there is a breach of one of the provisions listed in Schedules 13 and 14 of the bill. Clause 145 provides that regulators can go to court and seek an enforcement order. And this very much mirrors what we currently have, with one exception. And that is that a public designated enforcer can now ask the court to make the respondent pay a monetary penalty, which is quite a significant change. Clause 137 deals with consultation. Now, in my view, consultation has always been at the heart of enforcement proceedings. It's a matter of months whereby the parties exchange ideas and the trader tries to explain its position. And it was previously governed by Section 214 of the Enterprise Act. That remains largely unchanged, and it remains the case that it can be dispensed with in very limited circumstances. For example, when it needs to be made without delay, or a slight new addition in the bill where it's not reasonably practicable to ascertain the identity and whereabouts of the respondent. Clause 148 deals with enforcement orders themselves, and there's not much change there. It remains the case that the court must take into account whether an undertaking has been given, and if so, whether it has been breached. Clause 151 still provides for interim enforcement orders, and those are granted where the order is likely to be granted in the long run, and it is expedient for such an interim order to be given. Clause 155 deals with undertakings, and this is available to all enforcers. And as we all know, one of the best outcomes for any enforcement proceedings is obtaining voluntary undertakings without the need for court action. There is something slightly new in Clause 157, which covers the variation and release from undertakings. They might have been possible in any event, but now they're dealt with expressly. Clause 149 deals with enhanced consumer measures, which Rob touched upon. They're a fairly new invention domestically, and I'm not sure that there's any real case law on them where there's been a contest between the parties as to whether they're imposed. The actual definition of them is found in Chapter 8 of Part 3 in Clause 213. And you'll be glad to know the terminology hasn't changed from what Rob mentioned: redress measures, compliance measures, and choice measures. The test for them still remains broadly unchanged, which is perhaps unsurprising since they're fairly new. And finally, I've mentioned that it's still open to the CMA to obtain online interface orders as well as interim online interface orders.
So that's an incredibly helpful roadmap, John. Thank you for that. I wondered whether out of all of that, maybe you could pull out perhaps three of the most important changes as you see them to the court-based enforcement procedures.
Yeah, I think I've probably hinted at a couple of them. And the three that I would go for are, first, territoriality, which I'll explain in a moment. Second, as I've already mentioned, monetary penalties. And the third, the investigative powers that are available. I'll just make a few points about each. As to the first one, territoriality, I've noted that we now have this UK connection condition in clause 141 of the bill. But what it's really important to note is that clause 141(1)(c) includes a commercial practice and carry-on activities by the trader that are by any means directed to consumers in the United Kingdom. Now, one can see that this is an incredibly broad provision, and it's clearly drafted with international companies in mind, because as we know, much of consumer purchasing is done on the web now. And this makes sure that it's easy to target companies outside of the UK, which might not previously have been within scope.
It's very similar to the expansion of the Chapter 1 prohibition, which this bill also introduces for competition law and anti-competitive agreements, basically expanding the territorial reach of UK law to capture, i.e. big tech or other companies that are abroad. Rob, don't know whether you want to come in on that as well.
Yeah, there are parallels, but of course, what we've got to remember is this is the enforcement regime. So this is a provision which says you can bring proceedings in these circumstances. Obviously, there's a separate question, which is what's the scope of the substantive legislation, and so you've got to jump through both of those hoops. But it certainly is the case that this regime is intended to protect consumers in the UK from businesses wherever located, and of course that was always the case with EU consumer law as well, because that existed in the context of the single market, which obviously is intended to open up markets to consumers, irrespective of the location of the trader.
So, John, we interrupted you. Your second point was monetary penalties, I think.
Yeah, that's right. Finally, I'm sure most regulators will be saying they have the power, or at least public designated enforcers will have the power to impose penalties. So clause 150 deals with breaches of orders made by the court and undertakings given to the court. Now, monetary penalties are available in these circumstances where there's a public designated enforcer, and only if the court finds that the trader has already engaged in such conduct or is currently engaging in such conduct. You can't get a monetary penalty, obviously, in respect of future conduct. The amount is a fixed amount not exceeding the hire of £300,000 or 10% of turnover, so not insignificant in any way. It's worth noting, of course, that if a trader has already been found guilty of a criminal offence, a monetary penalty won't be imposed. And that's made clear in clause 156 of the bill. And as one would expect, a trader can appeal the imposition of such a penalty. Similarly, there are monetary penalties available if you breach an undertaking given to a regulator, and that's set out in clause 159. And that really, in my view, is a very important addition, because whilst courts could take into account the breach of undertakings, there wasn't much of a stick to make sure that traders committed to their promises, other than perhaps some bad publicity. So clause 159 allows for penalties to be imposed here. It largely mirrors clause 158. But I would note that there is a defense here, and that where you have breached an undertaking that's given to a regulator, a penalty can only be imposed if the court is satisfied that the respondent's failure in question is without reasonable excuse. So there is a defense there. And the amounts for those penalties are not exceeding £150,000 or 5% of turnover. Just very quickly, going on to the final point, which is investigative powers, and I'll really summarize them. As we know, some of the enforcement tools very confusingly are hidden away in the Consumer Rights Act rather than in the Enterprise Act, namely Schedule 15. And Schedule 15 contains the incredibly important power to serve what are called information notices, whereby you demand information from traders. This bill in clause 200 amends that schedule, so it keeps them in the CRA. And the amendments are, again, allowing for monetary penalties if you don't comply with an information notice, which is a real improvement, because without that, regulators would just have to go to court to enforce an information notice and would have to get at the back of the queue as any litigant would in order to get a court order on that. Other amendments and the expansion of powers are giving information notices to people outside the UK, which ties in with the UK condition that we've discussed earlier. And finally, entry to premises where documents are accessible, which as one would immediately appreciate, is a powerful tool. So those are really the three things that jump out at me.
Now, we're used, as Rob has said, under the Enterprise Act, having a unified enforcement regime for two categories of infringement. Infringements of what were community infringement, or since Brexit, the Schedule 13 infringements, and then on the other hand, domestic infringements. How is this old divide between European infringements and domestic infringements dealt with, if at all, in the new procedures?
Well, you'll be glad to hear that the Act really does simplify this area, because now there is just a single category of infringement. So the mess that the Enterprise Act landed up being due to constant amendments in this regard, and as Rob says, a lack of imagination in redrafting it, has all fallen away, and there's just a single category of infringement. And the kinds of infringements are listed in the two schedules, 13 and 14. And the only real difference between those is Schedule 14 sets out those infringements that the CMA can directly enforce itself.
Okay, and we're used to obviously three types of enforcer: the general, the designated, and community or Schedule 13 enforcers. Presumably that's also been simplified as well, has it?
Yeah, quite right. It has been simplified. Clause 143 deals with the categories of enforcers. So gone are the general enforcers, etc. Now we just have two types: a public designated enforcer, and designated means designated by the Secretary of State by way of regulations, and a private designated enforcer. And I think the name says it all, and little explanation is needed. How one is designated and the requirements to be designated have moved away from various orders made under the Enterprise Act and are now actually contained in clause 144. It's probably right to say that even though the categories of enforcers have been changed, it's quite clear that the CMA retains its top spot as the key regulator in this field, and clause 146 enables it to give directions to other regulators, and it's also entitled to get information from other regulators by way of other clauses.
Okay, so I think that's the changes to the consumer-led enforcement procedures. Let's now move on to discuss the CMA direct enforcement powers. I think it's fair to say, George, that the bill significantly bolsters the consumer law enforcement regime by enabling the CMA to take action to enforce consumer law through administrative proceedings rather than requiring them to take court action, as Rob was talking about earlier. But I'd like us to begin with where the idea behind giving the CMA direct enforcement powers has come from.
Yeah, well, probably the origin could be found in the Penrose report. John Penrose, who is a Conservative MP, was asked by the government in, I think in 2020, to report on improvements to competition policy. And somewhat as an aside to that, he added his thought that he could see no reason why, given that the CMA had power in the competition space to impose of its own, on its own account, as administrative penalties, very significant fines for competition infringements. He couldn't see why that wasn't the case also for consumer law infringements. So that idea has now been picked up and run with, and you now have chapter 4 of part 3. So we were, in addition to what one might call a prosecutorial regime, we've now got if you like, a sort of Competition Act style enforcement regime.
And what's the basic procedure for that new regime, George?
Yeah, well, those of us who are familiar with the Competition Act process will find a lot very familiar here. So you start off with a power to investigate, which is based on a reasonable cause to suspect. It's a power to investigate what are called relevant infringements, and effectively one's back to what Jonathan was talking about in relation to chapter 3. So exactly the same kinds of conduct. A court, you've got the same provisions on territoriality and so on that you find in chapter 3. The CMA can look at past infringements, ongoing infringements, and also likely future infringements. And it can look at the possibility of taking action against accessories, presumably individuals, as well as sort of intermediary companies. So it could start an investigation. It's obviously got to tell the companies involved. It can tell the wider world, but doesn't have to. So you get those. So that starts the investigation. You then have a series of investigatory powers, which are very similar to those it has that Jonathan was describing under chapter 3. One interesting provision is that it can order any business to prove the truth of a claim that the business makes as part of a commercial practice. So one obvious example is something like claims that the product we sell is very good for curing male pattern baldness. To take an example close to home, the CMA can ask the business to prove that, to produce all the research that it's got to demonstrate that that's done. And if the business can't do it, the CMA is then allowed to conclude that the claim is incorrect. And the CMA can also can also impose penalties for false provision of false and misleading information in the way that Jonathan was describing in relation to chapter 3. The next stage of the CMA then produces something which those of us who are competition lawyers will inevitably think of as a statement of objections. It's called a provisional infringement notice. Again, the purpose is much the same as the familiar SO in the competition sphere. It sets out the CMA's case, explains why the CMA has reasonable cause to believe that there's an infringement, and it sets out what it proposed to do in terms of directions, and also whether it's proposing to impose a monetary policy, and it's got to allow oral and written representatives. And the businesses at that stage can, if they want, suggest undertakings in lieu, and the CMA can accept those.
And at the end of that process, what can the CMA actually do? What teeth has this regime got?
Well, it can then impose a final notice, sort of equivalent to the final decision in the competition sphere, and there it's got to be satisfied that there's been a relevant practice, and it can impose. I mean, essentially, it's got sort of what one might think of as injunctive type relief, which are directions to stop the practice. Enhanced consumer measures, which Jonathan was talking about, online interface notice, as Jonathan was talking about, those are the same. So it can make orders, and those orders can be enforced, and the CMA can impose fines or daily fines for breach of those orders, again, similar to what happens in chapter 3. Then as far as the monetary penalty are concerned, again, it's very similar to the chapter 3 position. It's £300,000 or 10% of turnover, worldwide turnover, if greater. So the very serious amounts of money can be at issue here. Stakes are pretty high.
And I assume then the incentives to appeal have changed considerably. So how does one appeal if you think the CMA has got this wrong or behaved unreasonably or set a penalty which is too hard or severe?
Well, that's all set out in clause 194. The appeal lies to the High Court or the Court of Session in Scotland, and the grounds are error of law, error of fact, that the penalty is unreasonable, or the decision is unreasonable or wrong for any other reason. And it's clear from the explanatory notes that is intended to include the wrong exercise of discretion, as well as an error of fact or an error of a law. And indeed, the explanatory notes refer to this as being an on the merits review. The explanatory notes also say, and this appears to me to be right as a matter of construction of the provision, that the court will be able to hear fresh evidence that was not before the CMA. So the business can say, well, here's a whole lot of stuff we didn't put to the CMA, but is highly relevant to CMA's findings or to the question of whether the penalty is right or whatever. And I suppose you'll have the same arguments as you've then had in the competition sphere about how the court should approach that evidence. But the question, but the issue of whether it's admissible seems to be determined by the wide framing of the provision. So effectively, you're likely to have some form of mini trial if there are disputed issues of fact. You probably will have cross-examination of witnesses and so on. At the end of the day, the court has, basically a full panoply of powers in terms of what it can then do. It can vary the order, what the CMA has done. It can quash what the CMA has done. It can confirm what the CMA has done, perhaps on different grounds. It can remit the matter to the CMA, or it can make any order effectively that the CMA could have made. You're going to have to move fairly quickly, though, if you want to appeal, because there's a deadline of 60 days, so effectively just under 2 months. There is a power to extend, though.
And so, George, do you think we're likely to see that parallel in the consumer space, that this is going to become a new original jurisdiction as well?
Well, given the size of the penalties that are going to be imposed and the potentially wide-ranging effect of directions, enhanced consumer measures, etc., it's not hard to see that there will be a number of cases where companies are determined either to contest the findings or contest what could be a very substantial penalty. So I think the High Court and the Court of Session have got to be, we will see a number of cases there. One, of course, issue that's very much live in the competition cases, very much influences people's reaction to CMA decisions, is the possibility of follow-on litigation. Now, that's a bit less of an issue here because there aren't any provisions for follow-on damages. And though obviously in many cases, the sorts of things that companies will be found to have done to consumers are things where consumers would have various types of claim, the reality, of course, is that in many cases, those claims are going to be quite small, and there isn't any procedure for anything like the collective proceedings orders that one sees in the competition sphere. So to that extent, the stakes will be somewhat lower for companies. But if you've got a big company, there's going to be reputational issues as well as the purely financial problems of having to pay a penalty.
One interesting point, I think, is that obviously in the competition arena, we're used to penalties being calculated on the turnover of an undertaking, which isn't necessarily the party that's committed the infringement. I think in this context, the penalties are calculated with reference to the turnover of the respondent. So that's one difference, I think. But and then there's a definition of the respondent, which brings in parties that are involved in the infringement and accessories. But I'm not sure whether we'll have that kind of involvement of the ultimate parent company unconnected with the conduct. So that is one potential interesting difference.
And lastly, on this section, we've had an interesting question from the audience about what continuing role does the panel foresee for court-based as opposed to administrative enforcement in the future under this act? I mean, it's a crystal ball question, but do we think that there'll be more court-based action or more administrative enforcement via the CMA? John?
Well, even before answering that question, Jack, one point I would make is this. I'm sure everyone will agree that there's actually a surprising lack of jurisprudence in this country on consumer law, that there isn't a lot of case law on, for example, unfair terms or the CPRs. Lots of it is European law. And we do need a situation in which we start to develop domestic law in the High Court. And I don't know whether, well, certainly regulators will want, or particularly the CMA will want to use High Court proceedings in the first instance to try and establish precedent. But having said that, equally, if there's an appeal to the High Court, that too could establish precedent. So I think it's quite difficult to say at this stage, Jack.
Yeah, I mean, of course, in the competition sphere, one thing that that people have noticed over the years is that it's why people have tended sometimes to suggest that the competition procedure should move to a prosecutorial model, is that the process of writing a decision is a process that takes the CMA in the competition sphere, sometimes takes them a very long time, and you get this sort of great big doorstopper of a decision. And that's been identified by many critics of the current system as something of a roadblock that slows things down. And they say, wouldn't it be quicker if all the CMA had to do was effectively produce something like a statement of objections and then head straight to court? So it'd be interesting to, I mean, if that, if that is right, and if you can carry that analysis over to the consumer side, both of which are very much open questions, one might see cases where the CMA says it's actually just easier for us to go to court because that's rather, that may be quicker than the process of writing a great big long decision, which is then going to be appealed anyway, given that appeal is effectively as of right and can be simply on the basis that the CMA has got it wrong. So there's no sort of there's no sort of normal judicial review hurdle that you can't appeal just because you don't like the decision. In this case, you really can appeal because you don't like the decision. You persuade the court just to have another look. So in many cases, it's going to be pretty obvious that there's going to be an appeal. And in those cases, one wonders whether the CMA really wants to go through the process of writing a great big long decision rather than just effectively go to court armed with its preliminary findings.
I mean, yeah. I mean, having said that, coming back to the point I made earlier about the form of remedy, I mean, if the CMA is seeking to impose a more complicated scheme of ECMs and compliance measures and all the rest of it, you can see why they would want to give that definition in a regulatory decision. I call it a regulatory decision. Everyone knows what I mean, rather than go straight to the court and ask the court to impose that directly. So I think it may be a case of horses for courses.
Yeah.
Okay, so I think
and in many cases in this sphere, the company is concerned. I mean, particularly if you've got new management being brought in because something has gone wrong. So new management's brought in, they accept by and large that something's gone wrong, and they will be concerned. I mean, I think they may actually welcome being able to deal with this without court proceedings, because they may, of course, in those situations they often give undertakings in lieu. But if the CMA actually wants to go beyond that and have an order, this might be a sort of process that it's better for everybody than having to go to court.
So I think that deals with the procedural side, and it is, of course, the High Court and Court of Session, not the CAT. So thank you for that. We should now move on to substance, I think, which is part 4 of the bill. Now, there are a number of different strands to part 4 dealing with unfair trading terms, subscription contracts, consumer savings schemes, and ADR for consumer contract disputes. And Khadija is going to guide us through that maze. So starting with unfair trading, Khadija, what's changed, or indeed has anything really changed?
Well, the short answer is no, not much has changed. The defined terms are pretty much the same. The list of unfair terms is effectively the same. There are 2 minor changes that I want to touch on. The first is in respect of the professional diligence requirement, and the test at the moment under the current regulations is that you have to show that the breach of the requirement is likely to materially distort the economic behaviour of the average consumer with regard to the product. And that language of material distortion is now all gone, and the test is simply whether the lack of professional diligence is likely to cause the average consumer to take a transactional decision that they would not otherwise have taken. That may look like a change of substance. In my view, it's not. But it's a welcome change, because under the current regulations, to me, it's always been quite hard to understand how in practice the material distortion test is actually different from the transactional decision test. So that's the first minor change. The second change concerns the omission of material information from the invitation to purchase. And many of you will know that that's already an unfair trading practice to omit material information from an invitation to purchase. The bill takes this out of the misleading omission offence, which is where it currently is, and creates a separate offence for it, but the test is the same. So again, I think this is a change more of form rather than substance. On its face, it does look like there are lots of changes, but actually these are changes to structure and drafting, which I think are good because overall the bill seems a lot clearer and easy to navigate and understand for the average consumer. But they aren't massive substantive changes there.
Okay, so the 2008 consumer protection from unfair trading regs have essentially been repealed and replaced by a new regime with a few minor tweaks around the edges. So that's on terms. The bill next deals with subscription contracts. So first of all, let's deal with what actually is a subscription contract. Okay, so subscription contracts, I mean, we must all have subscription contracts, particularly online subscription contracts. They're so popular. It's a very hot topic, and it's therefore quite surprising that up until now there hasn't been a statutory definition of a subscription contract. It doesn't exist in the existing regulations. So the bill introduces this for the first time, and the definition is at clause 246. In summary, a subscription contract is one which applies to the supply of goods, services, or digital content, and it must be either a contract where there is an automatically recurring or continuing supply with payment for each supply, and where the consumer has the right to bring that contract to an end, or alternatively, it's a contract where you have an initial period of free or discounted supply, followed by a subsequent period of paid for or full price supply, and again, where the consumer can bring that contract to an end before liability is incurred. There is a very long list of excluded contracts, and that's in Schedule 19 of the bill. It includes things like package holiday contracts, gas and electricity contracts. I won't go into those, but you should know there is a long list of carve-outs. Okay, so let's assume that one has got a subscription contract. What are the new duties on traders in relation to those contracts, Khadija? Yeah, so there are a number of duties. There's a duty to provide key pre-contract information, and that's set out in Schedule 20. I won't go through all of it, but to give you a flavour, for example, if you've got a subscription contract where you've had this free initial period of supply or discounted supply, the key information the trader must supply is that there will be a subsequent period of either charged for supply or a higher fee for supply, and also the date upon which the consumer becomes liable for that higher charge. So that's one duty, key pre-contract information. Another duty is to provide or to make available full pre-contract information, also in Schedule 20. That includes the kind of information you typically see in contracts, the small print, the main characteristics of the goods and services, trader's identity, business address, data address for service, etc. There's a duty to give all of this information as close to the time of entering into the contract as possible. And it's really important that the key pre-contract information and the full pre-contract information are given separately. There's a duty to give them separately. I think that's because you need to stop consumers from being deluged by small print, and so they can easily see and digest the key pre-contract information. There are additional requirements around subscription contracts which are entered into online, which I will talk about because that's most subscription contracts nowadays. There's a duty to ensure that before a consumer enters into such a contract online, they expressly acknowledge that the contract obliges them to make payments to the trader. And there are requirements around giving reminder notices for the first renewal payment under subscription contracts. And there's also very strict timing requirements for this reminder notice. So it has to be between 3 and 5 working days before the renewal date. And I think that's a sweet spot that someone's calculated. So not too early that someone receives it and thinks, oh, I'll do that later, and then forgets all about it, and not too late that you don't really have enough time to actually cancel before your time runs out. And then there's provision around consumers' cancellation rights. So you have to be able to cancel in a single communication, and you shouldn't have any unnecessary steps or barriers to being able to do that. Okay, now obviously as litigators, we're interested on behalf of potential claimants, how claims can be brought, and obviously when we're representing defendants, advising about what risks there are for litigation arising out of this new subscription contract duty. So what rights do consumers have if there's been a breach of any one of those duties that you've just outlined?
So there's a right to cancel the subscription contract if there has been a breach of the duty to provide the key pre-contract information, so the key stuff. There is a right to cancel where you haven't received a valid reminder notice, and there's a right to cancel if the consumer hasn't been able to exercise their cancellation rights in the way that I've just described. There isn't a statutory right to cancellation if the full pre-contract information hasn't been given. But obviously there will be other contractual rights and remedies in that case.
I see. And very quickly, are there any cooling off periods?
There are cooling off periods. There's an initial cooling off period from the date the contract is entered into, and that's 14 days. There's also a renewal cooling off period, and it applies to contracts where you've had that period of free or discounted initial supply, and then you're going to be ramped up. There could be ramped up charges. There's another 14-day cooling off period from the date of renewal, or if you are tied into a subscription where the renewal is like spaced at 12 months or more, so like an annual subscription, in that case there's another 14-day cooling off period after the renewal takes effect.
Moving on because of time to a slightly different topic about fake reviews. Now, there's been a lot of media coverage around fake reviews in the press generally, but also in relation to this bill specifically. But what does the bill actually say about fake reviews?
So the bill doesn't actually say anything about fake reviews. So in that sense, the news you've referred to may be a bit of fake news. But what happens, what is happening is the government recognises there is a problem with fake reviews, and they're contemplating banning either commissioning someone to write a fake review, posting reviews without taking reasonable steps to check they're actually genuine, and offering to submit or facilitate fake reviews. And they're going to consult on these potential ways forward. There is, the legal point is that there is a power in the bill for the Secretary of State to amend secondary legislation to do one of these things if they decide to do so following consultation. But the bill doesn't actually talk about fake reviews.
Okay, and consumer savings scheme contracts is another area, which is a bit of a niche area of the bill, but could you briefly tell us what those type of contracts are?
Yeah, so a common and high profile example of a consumer savings scheme is like a Christmas savings club. The statutory definition is at clause 274, and it's where a consumer makes payments to a trader. The trader holds those funds in an account for the consumer, and then the consumer can use the credit they've built up in that account to purchase goods, services, or digital content during a particular period. And to me, it seems like the legislation is trying to ensure that we don't see a repeat of the Fair Pack collapse we saw some years ago.
And what protections does the bill put in place to protect consumers from that sort of thing happening again, the Fair Pack situation?
Yeah, well, essentially, it's about insolvency protection. So what happens if the trader who you've been saving with goes bust? There's now a duty on the trader who's operating the consumer savings scheme to ensure that there is insolvency protection in place for that eventuality. And to deliver that protection, they must either make sure the funds in the account are insured or that the funds are held on trust for the consumer. And the trader, and this is important for consumers, there's like an information requirement, and we see this in lots of provisions. They must inform the consumer about the insolvency protections they have in place, including either providing a copy of the insurance policy or providing a trust deed. So that's it for me on the consumer savings contracts.
Excellent. There's a really interesting question about the unfair trading regime and the restatement of the consumer protection unfair trading regs, and whether greenwashing will be prosecuted under the new legislation. As I read the list and the restatement of the list of misleading omissions and aggressive practices, for example, there didn't seem to be a new one inserted specifically about greenwashing. I think it might come under the delegated power to introduce new practices. Is that your understanding as well, Khadija?
I haven't seen anything in relation to greenwashing, so I agree. It's probably one of those
and then
for the future.
Yeah, there's another question that's asked us for the panel's view on what kinds of offences the CMA is likely to use its new powers to punish, beside the obvious unfair commercial practices under the CPRs that we've been discussing. And an example is given. Does the panel have any view on whether the CMA may use its power to impose penalties for breaches of the Consumer Rights Act for example? Rob, I see that you're keen to potentially answer that one. I'll have a first go.
Yeah, no, but it's an interesting question, and actually, historically, when you've been looking at the way that the enforcement regime bites on unfair terms conduct, the enforcement regime is all expressed in terms of dealing with conduct and stop the conduct. And actually, there's always been a bit of a mismatch between that regime and the unfair terms side, where in fact it's not really a conduct-based piece of law at all. It's all to do with the nature of the term, and the term having no legal effect because it's it's either on a banned list or it fails a substantive legal test. And I think the question in a way brings that debate back to life in a different context. I mean, I think what I would say is that if you think about the experience in the competition area, it's well established that fines in the competition context serve two purposes. They deal with the seriousness of the infringement, and they deal with deterrence. And I suppose, in part, the question might tease out the fact that adopting a campaign of misleading information actively is more serious than a misleading omission potentially, and an aggressive conduct is worse than both of those, and that possibly including an unfair term in a contract is less serious than that sort of conduct-based regulation. I'm not really sure, actually, though, in terms of consumer harm, whether one is more or less serious than the other. If you include a term in a standard form which applies to every consumer that enters into a particular form of conduct, then that's capable of generating enormous consumer harm. It really depends on the prevalence of the practice. And if the purpose of the penalty is not just to resonate in terms of the seriousness of the conduct, but actually to try and bring about deterrence and to try and make effective to give people a proper incentive to put themselves in line for the future, and indeed not just these parties, but other parties operating in the same space, then that's a justification for a penalty, which doesn't really depend on this kind of hierarchy of seriousness. So I think it's a really interesting question. And I suppose if you're the CMA looking at this, you're probably going to want to use your penalty power to try and maximize consumer protection and maximize the effectiveness of the regime, which may not always map onto kind of orthodox sense of what is serious and what's not serious.
And it leads to another question from me. What does the bill actually not do? Is there any missed opportunities or potentials for amendments that we see during the legislative phase? I mean, George has already mentioned the fact there's no change to follow-on actions or group litigation, for example. There's been a lot of talk about expanding the opt-out regime that's in the CAT for competition law claims since the Consumer Rights Act into the consumer law. We touched upon greenwashing, and I suppose the only other thought I had was, is this a missed opportunity for even greater consolidation? That consumer law is one of those areas which is renowned for lots and lots of statutory instruments and delegated legislation. And it seems that this bill, from what Khadija has said about unfair trading conditions, suggests that it may, and practices, may more powers for further delegated legislation. So I don't know whether the panel has any views on missed opportunities or things the bill doesn't do that it could perhaps have done.
Well, just to engage on one of those things about the absence of a regime for compensation and group action, that's true. But it is, of course, true that the CMA has the power to impose redress schemes. And that's quite different from the competition space. So in the sense, one regime may be missing, but there is something in its place. And I guess in an era of compensation culture, to use that sort of slightly vulgar expression, it will be interesting to see actually whether that regime gains traction either as part of the admin regime or even through the courts, because ultimately, of course, a court imposing a redress ECM at the end of a piece of contested litigation, it's obviously not on all fours with a group action, and it's going to be prosecuted by the enforcer, generally speaking, rather than by the consumer or a class representative. But it's potentially an important regime, and we've already seen it in action in the CMA's current caseload.
And someone...
I would also just add to that, Jack, very quickly, that even though we don't have a follow-on regime, etc., one has to look at the reality of the situation. And if the High Court makes a decision that a term is unfair or that there's been a misleading action, even though that is not binding on other parties, one would think that a trader faced with that judgment would face numerous complaints from consumers saying, look what you've been told about your practices, and would probably result in settlements of such claims rather than them being litigated as small claims.
Yeah, I suppose it depends if the consumer finds out about the court judgment, takes legal action, which was one of the reasons for the competition law claims, very small value hassle factor type claims. I think there's one comment which I haven't obviously had time to check the validity of, but somebody has suggested that there is one omission in that there's no responsibility of online marketplaces and intermediaries with respect to some of these consumer duties. There's obviously the digital markets half of the bill, which will produce a number of duties upon them, and maybe some of the fairness remedies which were discussed last week in our last webinar on the topic will have some bite in that area as well. But I think we've got time for one more question, which was one about when the new CMA enforcement regime comes into force and how far back will the CMA go in terms of deciding to investigate past breaches, if indeed it can have retrospective effect. John?
Yeah, as is usually the case with these things, it's always far more complex than a simple answer. The transitional provisions are set out in clause 208, which itself just refers to Schedule 17. And when it comes to Part 3, it says that the enforcement regimes will replace the regime provided by Part 8 of the Enterprise Act for conduct which takes place after commencement. So if you want to use the new scheme subject to various complex transitional provisions dealing with matters such as continuing conduct, etc., the conduct itself would have to take place after this bill coming into force.
Yeah, I see. Okay, so I think that takes us bang on to the end of our allotted time. So it just remains for me to thank the speakers for what I think was an excellent session, and thank you everyone for joining. I hope we've answered many of the questions that you've had. And obviously I think we'll have to come back when this is an act to talk about the practical implications and any changes from this bill before it's enacted. But thank you very much, and thank you for joining.